So if you missed any classes for this lesson, as you can see, there's quite a few rectangles right here. So let me take you through what we did in case you missed class. So the first thing we started off with is this PowerPoint right here that had the basics about civil liberties. There were also some multiple choice questions, and if you missed those, do the best you can, but the answers are right here. So that is the first part. And then we got into the heavy lifting, these cases here. And there's no other chapter with more cases than chapter 4. And if I click on this, you will see there are 24 cases. And obviously that's a lot. So we divided into pairs, and one person was in charge of 12 and the other person was in charge of 12. Now, how you go about studying these cases, if I can make a suggestion to you, I would use this oyez.org site. Does a really good job breaking it down in a way you understand. So with your partner, you did the heavy lifting, you researched it, and then we presented it as a class. And what I asked for were people to break down the cases into something very succinct so you can remember what it was about. And I hope you got the big point that the Bill of Rights had a lot of Supreme Court cases gauging the constitutionality of those Bill of Rights, because in a sense, the language is vague, and because we engage in these rights every day, there's going to be cases that follow. So what I'm going to do is I'm going to cut to the culminating activity. I'm taking one of your classmates' PowerPoints here. So thank you for the people who made this. And I'm going to share with you what the class came up with about the succinct version of each case. Okay. So here's case number 1, Barron versus Baltimore. Had to do with state responsibility compared to federal responsibility. Gitlow versus New York. Protected speech. What is protected speech? Also protected press. Okay, a First Amendment issue. Neer versus Minnesota. Protected press. Okay, lots of cases. You can see they span through time. I mean, Barron was 1833, a lot of cases. Lemon versus Kurtzman. The separation of church and state. That's what Lemon versus Kurtzman had to do with. Miranda versus Arizona. In fact, a lot of people in class could recite the Miranda. You have the right to remain silent. Anything you say can or will be used to you in a court of law. And the backstory is Ernesto Miranda did not understand his rights. So since this, you have to make sure the accused understands their rights. We even call them Miranda warnings after this case. But a lot of people already knew that one, which is pretty cool. Furman versus Georgia. That had to do with the death penalty, and the death penalty goes with the Eighth Amendment, cruel and unusual. Gregg versus Georgia. Again, death penalty. If you look at the 70s was the time a lot of Eighth Amendment death penalty cases were coming down the pipe. That was a real hot button issue back in the 70s. Now, Gideon versus Wainwright, this is the right to an attorney. And Gideon, he wrote it down on lined paper and pencil to be heard, and went all the way to the Supreme Court. And now everybody gets an attorney, has a right to an attorney. If you don't have an attorney, it's not constitutional. Griswold versus Connecticut. They had to do with contraception, but contraception is a form of privacy. Whether you're using contraceptives or not, that falls within the Fourth Amendment, okay, privacy. Roe versus Wade is the one people knew about before we even started. Obviously, abortion. And in recent times, abortion has gone to the state level after almost 50 years at the federal level. So that has to do with Ninth Amendment, enumerated powers, the 14th Amendment, rights and privileges to all citizens, that sort of thing. Lawrence versus Texas, again, privacy, Fourth Amendment rights. And now we're getting into the 21st century, and the death penalty being a hot button issue in the 70s, gay rights issues became more, I must say, prominent or prevalent, however you want to put it, in the 21st century. Planned Parenthood versus Casey. Again, another abortion case, Ninth Amendment, enumerated rights. And abortion's been a hot button issue for about a long time. Okay, it still is politically. And Hey, you can get a class pretty riled up by bringing that issue up. I think you've seen that before. McDonald versus Chicago, there's a Second Amendment case about guns. The constitutionality of guns, when they can be carried, can they concealment, all these sorts of things. So there's a lot of cases regarding the Second Amendment. Mapp versus Ohio. This is a privacy case, a Fourth Amendment case, and a big one. You're going to see Mapp versus Ohio several times in this class. High likelihood it's going to be on the AP exam. Zellman versus Simmons Harris. That was another case about church and state, the Establishment Clause. Okay, and that's tough because you have the Free Exercise Clause and the Establishment Clause, and it's a bit ambiguous to what's what. And there have been several cases to gauge the constitutionality of church versus state. Engel versus Vitale, this is the separation of church and state again. So to reiterate my point, a lot of cases. Employee division versus Smith. This is freedom of religion. And freedom of religion is a First Amendment issue. Obviously, Schenck versus U.S. This has to do with speech. What is seditious speech? Are you allowed to speak out against America in general? Does it change during wartime? This sort of thing. Brandenburg versus Ohio, another one you are going to see again and again and again. This has to do with offensive speech. And when we learned about the First Amendment, offensive speech is pretty protected by and large by our Constitution. Miller versus California, freedom of press. What is obscene? What is obscenity? And again, that's a tough call. And what's obscene to one may not be obscene to somebody else. We have New York Times versus Sullivan. This talks about defamation. Again, another limit to the First Amendment freedom of speech. Texas versus Johnson, freedom of expression. Burning the flag. Now, burning the flag is probably offensive to a lot of people. However, is it constitutionally protected? Expressions like that, burning an effigy, for instance, is that protected? So if you burned an effigy of a president, is that protected, versus crossing that line? NAACP versus Alabama. This is a case about freedom of assembly, freedom of expression. So a lot of these cases having to do with the Bill of Rights. And the last one in class, District of Columbia versus Heller, another gun case. So that's a lot. I get that's a lot. And if you're saying, "Oh my goodness, El Cicholi, that's 24 cases. How do you expect me to remember it all?" Well, if you can remember the gist of the cases, that's great. And if you can even take it to a scale higher, that throughout our history, there have been a ton of SCOTUS cases looking at the constitutionality of our Bill of Rights. So if you are listening to this because you missed class, start here. Check your answers on the multiple choice, a little MCQ practice, and then put your nose into these cases, or at least look at your classmates' PowerPoints. If you want to do it on your own, use OYEZ. And I promise you, this is the chapter with the most cases. I'm never going to give you more than 24 moving forward. I promise. Okay, so don't freak out. And for those of you who are going to law school, that's just a small taste of what you will learn about. So hopefully you enjoyed them, because you're going to get a lot of them. All right, so I appreciate you watching.